This, I've just discovered this in American law. Federal question jurisdiction. Federal question jurisdiction. Federal question jurisdiction is one of two ways for federal court to gain subject matter jurisdiction over a case. The other way is through diversity jurisdiction. Generally, in order for federal question jurisdiction to exist, the cause of action must arise under federal law. Well, that's really... But when you actually go into this, it's actually got a Wikipedia page on it. Where's the Wikipedia? Federal question jurisdiction. So, this is what Robert F. Kennedy filed his case to YouTube under federal question jurisdiction. When I've just read, I'll tell you what it says in a minute, but I think this is actually the cause of a lot of the problems in America. So I'll just brief you on what it says. We'll go into it in a minute. It says that they gave some jurisdiction to the lower courts, but then they took it away for them to hear some cases because they were worried that they'd have too much power. So they took it away, but then they've given it back to them again. Now, with that knowledge now, these lower courts, they gave them this federal question jurisdiction and took it away because they thought they might have too much power, and they're giving it back. But it's not just power. I think they've made an absolute, complete and total mess of the whole Constitution. And that is because Americans just love lawsuits and they think that they can, sue anyone. I think that it's like settlement. I think it's because the First Amendment goes on about settling grievances. I think Americans like to settle grievances, so they can settle grievances over absolutely anything. But it's meant to be settling grievances with the government, not with your fellow citizens, with the government over law or something that the government's doing. Now, from reading the case study about all the copyright law in America, the use of material for political purposes, when political rights is meant to be one of the uses, and it's meant to be an exhibit in proceedings that you're using it for when you're using it in an election or a petition. You might be selected it for evidence to demonstrate something or show something. And the paper that I've got, it cited that Eldred 1 and Eldred 2, and it said that full immunity had been proven at one time, but it turned out that Eldred 1 and Eldred 2 was actually about freedom of the press. Congress shall make no law, but they made a law for this Mickey Mouse law to change the duration of a copyright so it lasted longer than a lifetime. And there were some publishers who were challenging that they shouldn't have really made it because it's against the First Amendment. But that's actually really interesting because firstly, that paper that someone had written about all the different copyright cases is wrong. It cited misinformation. And then another point is, all these cases of people, they don't sue that often. In fact, the way that the politicians act and behave is that as if they have got immunity and protection with copyright law and they can do it. It's only when someone gets annoyed that they sue, like, Neil Young sued over the use of his song or whatever. But if it's like, a small matter in local areas, they don't usually bother. Now, I don't think they can sue because what it's been used for is evidence in proceedings, and that needs to be clear and understood of what the petition process and election process is. And I think that the copyright law facilitates for providing that, but what it provides is full immunity. Now, I think that all these lower courts, federal question, right? The district court shall have original jurisdiction over all civil actions arising under the Constitution, laws, or treaties of the United States. Yeah, well, Constitution, well, that means she'll have jurisdiction to say that, if someone tries to do something and they're protected, then they're allowed to use it as a defence. That's effectively like in the Human Rights Act, Section 7.1b. that I hold so dear, that says that your rights can be relied upon in any proceedings, providing that if it wasn't, that you'll be a victim. You'll be, if you couldn't, basically, you can rely on your rights as long as if you don't use them, you're going to be a victim of something unlawful. Well, if you all medical rights, if they withhold the medical right, basically, then they're breaking the law. That's it. You will be a victim, because if they refuse your medical rights, you're then a victim. And also the same with political rights. All prosecutions are illegal. You can rely on the rights in proceedings, political ones, when needed, when it arises. Otherwise, you are a victim, because it makes that clear. It creates it. All prosecutions are illegal, so you're being treated unlawfully. Subversion of the laws and liberties of the realm by evil judges, or even ministers. If ministers refuse to represent you, which the Petition Committee are refusing to. So this bit here, the district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Well, yeah, they've got the jury. That means they're allowed to, if someone's doing something illegal, they're allowed to say, okay, then you have to stop doing that to them. Now, with the copyright, Article 3 of the United States Constitution permits federal courts to hear such cases so long as the United States Congress passes a statute to the effect. However, when Congress passed the Judiciary Act of 1789, which authorized the newly created federal courts to hear such cases, it initially chose not to allow the lower federal courts to possess federal question jurisdiction, for fear that it would make the courts too powerful. Well, that's the problem. They are too powerful now. In fact, in England, they don't even acknowledge that you can have a right or a federal. This federal. There's one good thing about this federal question law. It acknowledges that there's federal law and that it might apply and you might be protected by it or can claim it and you can hear it in a court. And that's a special matter, which is what happened to me at Leicester after a lot of persuasion. I got Emma Fudge. This is why she created the separate hearing, but it's not actually civil, because on that form that I've just complained to the court that Robert F. Kennedy was in. I've complained about the judge, but there's a couple of buttons to select. Like, is this civil case? Different type areas of law, and actually, it's a federal question. So federal question isn't on there. So I ticked other, which is federal question. Now, so that means that it's not civil. It's not a civil matter. It's a federal question matter, which is a federal law matter. So, at least in England, you see, the overriding objectives to recognise the rights of the defendant is also this bit here. So the district court shall have original jurisdiction over all civil actions arising under the Constitution laws. So original, that means at the start of the case when the matter first arises. It doesn't mean original in a historic time, as in like a period of time in history. It means like, when the matter arises. So when you first get issued with any court notice or matter, then it can be dealt with by them. So now this is the problem with Extinction Rebellion cases. They act and conduct themselves as if there is no such thing as any immunity or Bill of Rights or protection or anything. They're made to defend the charge and submit a defence, which is not. That's normally it's not. It's not even civil. They're not even setting aside a civil matter like they did with me. And if you get Jonathan N. Fuller, all he wants to do is somehow turn around the proceedings so they can prosecute the government for polluting the environment or global genocide. He tries to. I think Jonathan N. Fuller wants to try and transform the defence case into a case against the government and get the courts to kind of agree that the government are corrupt. But they're not here to do that. They're here. So Jonathan M. Fuller is always, his mind is trying to change and steer proceedings, turn it into some sort of trial against the government. That's what he wants to try and do, and hopefully they try to say these things in court that could make the court somehow say, oh yeah, the government's corrupt, and then somehow make some sort of order that has some sort of, I don't know, agreement or effect, when they're not there to prosecute or have an action against the government. They're there to defend the charge. But you can claim rights. This jurisdiction in these matters of constitutional laws and treaties, well, it actually applies under the overriding objectives, and it is under the overriding objective that all rights have to be recognised, but it also is in the Human Rights Act as well. Well, it's a human right. Overriding objectives apply rights. What are the law for rights? The Human Rights Act. And then some acts have rights in there, like the Town and Country Planning Act, so there's the use of an enactment, which can be a right. So the problem, I think, in America is kind of like it's sort of like the opposite of here. Here, they're not even, they don't want to entertain that it exists. What we over here, we kind of need this federal question. Although it won't be federal question, it would be, right, constitutional rights. But, in England, just, parliamentary privilege even, privileges. So, but they don't even, the court, it doesn't even scan on the courts. They just get on with the defence and pleas. We could do with something like that here. And then you actually, well, I did get sort of that. I kind of did get it myself, but I didn't actually prove it. Like RFK basically has just been in, and he did this federal question, but he didn't get them to agree with him. That's basically what happened to me at Leicester, sort of. So really, I was in a similar sort of situation, although RF Kennedy wasn't facing prosecution, but he was trying to get his channel videos back up, sorry. Now, in America, they do have this federal question about constitutional law. And what they're saying is that, so the federal courts possess federal question jurisdiction for fear that it would make the courts too powerful. Well, we haven't got enough power. They don't acknowledge any kind of thing over here with ours because they don't want us to have any power. And it is making the courts too powerful by it not existing. Now, in America, it's made, what they've basically done is they've kind of washed it out. They've kind of like, what they did over here is they've kind of like, just like said, oh, I don't know what we're talking about. No such thing exists, right? And that's given the courts immense power over all these political actions. In America, they've done the opposite. They've literally put the fire out, like, with a fire extinguisher. They've said, oh, yeah, we've got this thing and you can use. And what they've done is they've let, instead of, so with those copyright cases, if you are doing a petition or election, then you will be using that right to use the material in your campaign, right? So what this has allowed to happen, I think, over these, federal questions and copyright laws to deal with it, to be able to deal with them in the lower courts, has enabled, because they've let the lower courts deal with it, a lot of people, I think, who, people have copied their stuff, they've kind of let them have a go at it, because Americans just like suing people, like to have a try, rather than saying, no, the people who aren't engaged in proceedings aren't actually using the right themselves or claiming it. What it's allowed is everyone to actually attack the rights, and then they start winning, and then it's almost like that right, you haven't really got the right, or it doesn't really apply, or even if it did or does, you have to argue it or fight for it, rather than it applies and you've got it. So rather than the people who are using the rights, using these courts and this federal question to enforce their right and validate it and protect it, what has happened is that instead people have challenged other people who are using it and challenged whether they can even use it or not, or whether it's valid, which that's wrong, because you can't, you're not supposed to challenge it. You're supposed to use it but it really, it's meant to be that, where's the Wikipedia thing gone now? Has it disappeared? Oh, it's here. You see, what this really equates to: the district court shall have original jurisdiction over all actions arising under the Constitution, laws, or treaties. Well, you only really would have an action arising if you were using the right. Because why else would you be there asking a question? And that, to me, that gives it all away. Because what do they call this process? What's the name of it? It's called a federal question. It's called a federal question. You're asking a question, right? A question, or I need to confirm something, or we need something confirmed, validated. I ask you something, right? Can I have my rights, please? Or can you validate or confirm my rights? In England, apparently, I don't know if they've got the equivalent, if you could go to just a normal local civil court or what. But usually you have to have a response, like you're a plaintiff and a respondent, or, you're being charged. Usually you don't just go in to, clarify something. But in America, it's used a lot more for clarification, which is why appeals are more for to solve technical problems or errors in America. It's a federal question. So if you are bringing federal question, you're not prosecuting anyone, because it's not a prosecution. Right? And you're not claiming against someone because it's not a civil action. It's a federal question. Why would you be there asking a federal question if it weren't rights either relating to you or someone else? But, I think that they do actually use copyright. They likely do just normally bring a copyright claim. And if the person defending raises a First Amendment, maybe it does go over to federal question on that, and if they've lost, then that is seriously going to hack into the rights and really deteriorate them, because the federal question should be like with copyright law: am I eligible or not for it? Not, is it protected or not? I mean, this is the thing. I mean, the evidence is meant to be protected. All prosecutions and commitments are illegal for the use of things for petitioning. So, I mean, the only questions arising will be: are you really doing a petition? And is this really, are you really using this for your petition? That's the question, What are you doing? Are you really doing this? This is a thing. But it seemed, I think that they've literally watered it down like cordial, which is totally opposite to England, because they're not even, they laugh, courts laugh at the right to petition and immunity. They joke at it like it's some sort of parliament law, some sort of parliament right that applies to you in a, criminal charge or civil case or something else. The Extinction Rebellion haven't been doing any of this at all. The Extinction Rebellion need federal question. I think they might have been using it in a lot of these political cases, but rather than using it and raising it in defence, I think unfortunately, I think it's kind of being attacked. And what I think some people have been using federal question when they themselves aren't actually involved in a campaign or claiming a right, like maybe the police. Maybe the police are raising question like, oh, can we, prosecute all these people, please, and then if they get it approved, then I really don't think that it was intended for people who aren't really using the right. I think it was more for people who were using it or when they're eligible to claim it, if there are any questions arise over it, or maybe if there's someone making an inquiry, like I'm planning on doing a political action, or I might want to do run for president or whatever. It's called question, so it's getting clarification, or maybe even like say for example for tax, like I've been looking into 8BNE forms for TuneCore. I'll probably use it even there. Like, look, I'm going on TuneCore. I'm publishing some political music, and I'm not a business, but where can if I file tax for non-profit, which I am non-profit, because this is for promoting a campaign, not to make money. Can we accept monies from TuneCore, which will they be regarded as donations? Will it be regarded as fundraising for the campaign? If we use it for the campaign, if it's promoting the campaign, and if it's for purposes of getting elected, can we accept money from it, which won't be regarded as business profits, private, if it's recirculated for more promotion, or for travel for the campaign, things like that, clarification on things like that, really. But I think that it's with this whole culture of just suing each other in America, maybe they get sparks from that, settlement of grievances, how it's written in the First Amendment, settlement of grievances. I think they play off that and they have their grievances with each other, whereas it's meant to be settling grievances with the government, not with each other. This is why, people are just banning and blocking each other now in these Facebook groups, particularly political ones, when they're intervening in other people's participation and so forth. So it's getting a bit bedlam now. I think that they've kind of like literally overdone it, and what they've done is they've sort of just diluted it. Whereas over here, it's given the courts power by not even acknowledging that there is some sort of separate track or procedures, which they clearly have acknowledged it in America for a federal question over my constitutional rights. But I got it in a way through, but in civil, it got labelled civil. It should have really been heard there and then, because it should already be known. The thing is, it should already be known in America anyway. They know what their rights are. I mean, since when are there any federal questions over? I'd like to see how many federal questions there are over medical law when they're all supposed to know what the medical law is. How many times do you question? Although sometimes when people get mishandled in police stations and so forth, I actually got taken to hospital and got a doctor's checkup. But I know some people have, some people don't get treated when they're in the cells, and so forth. But anyway,